with us today. I welcome our professors, Dr. Manjur Ellen ma'am, Ratnavali ma'am, Sunanda Bharti ma'am, Siddharth Mishra sir, and our respected PIC Anju ma'am also will be joining us shortly. So we have student participants from first year, and I welcome all of you too. It's a very big opportunity for all of you to have this session. I'm sure you all are studying and preparing hard for your exams, and I also understand that you must have been through some tips which are given to you from your seniors about how to write answers in the exams. And I teach first year, and I have heard some of the most absurd tricks and tips जहाँ पे students ने बताया है juniors को that write anything relevant or irrelevant, but write more. Fill those pages and you'll score more. If you don't remember name of the cases, you can make those names and it's okay. Nobody would come to know, and you can still score good. So we are here basically to bust all those myths and to tell you the correct way as to how to write the paper. For your answers, basically, I would like to say one little thing that answers they communicate your knowledge and understanding about the topic in question. And accordingly, you fetch a score. For this, it is very important to understand the question and then prepare your answer strategically in a well framed manner so that it leaves the best possible impression on the examiner and conveys your thoughts, knowledge, and information in a very non cluttered manner. So, and how would you do that? This is the question for which you are going to find an answer today. I'm sure you are going to take away some of the very important answer writing skills from here. And so I will now hand it over to our learned professors. First of all, let me call Dr. Sunanda Bharti, Professor Law Center 1, to begin with the session. Ma'am has a very vast experience and a tremendous knowledge of her subject. And today it's an honor for all of us to hear from her and learn from her. So welcome, ma'am, and over to you.
Yes, thank you, Dr. Shivani. I'm happy to be of assistance, and hopefully, what I share here today is going to help and guide the students to answer in a better way. Um, so let me start. And the first thing to begin with is this. I would ask the audience to spend 20 seconds on uh, just absorbing the lesson that it intends to put across. So, the first and foremost thing is, irrespective of how much you have prepared and how much of an effort you have put in the exam, if you resort to unfair means, then all is lost. There is so much at stake that I don't think it's almost a no-brainer to even emphasize the importance of it. So do not cheat because everything goes down the drain then. All your effort and hard work. That is something basic that I would want you to take away from today. Once you get the question paper, if you are approaching the question paper with or the questions with this mindset as to who cares what it is asking for, I have learned everything, and whatever I have learned, actually, that is what I'm going to write, irrespective of what the question is asking for. Then the very unhealthy sort of approach, mindset will be corrected because the question, the domain of the question has to be respected. The expression of the question has to be read, understood properly, and then you should begin with your writing bit. So do not look for keywords. Once you have gotten the question paper, do not look for keywords. Keywords is an expression that I have borrowed from the computer language. So basically, once you get the question paper, that has been my experience at least for the past 20 years, that the students, they mentally do a control find. जैसे कि हम कंप्यूटर में करते हैं control find, we tend to do a control find on that question paper, and we look for keywords. Say, for instance, if I want to attempt, I have prepared feminist legal theory as a topic, and I want to answer. I'm looking for a question that is based on that topic, right? So I'll
do a brief scan of the question paper, and the moment I hit upon the word, the moment I get my eyes perceive that keyword, feminist legal theory, or even feminist, anything even remotely connected with feminist legal theory, I start reproducing. The mind works in this fashion that okay, अब तो ये आ गया now. My task is just to reproduce whatever, vomit on the paper, whatever I have managed to, whatever I had learned, or whatever notes I had prepared on that particular topic. And if that is an approach that needs to be guarded against, because you need to respect the question, what it is asking for. You need to first read it and understand it properly in the complete sense of the term. So do not look for keywords. Do not do a control find. Uh, Go the old school way would be my suggestion. It was a very wise thing that we used to do back in school, wherein 5 to 7 minutes, 10 minutes, perhaps the first 10 minutes was supposed to be devoted to just reading the question paper. Okay. And that is a very good approach. It is a healthy approach because you get to know, okay, you get a fine sense of what the questions are on, what are they asking for actually. Okay. So do not look for keywords. Do not write with a preformed mindset that okay, I had prepared my stock notes and this is what I'm going to write. Because if that is the approach, it results in a lot of irrelevant, useless content in the answers. And despite the fact that you might have filled in pages, so called, you tend to lose marks because whatever you had written was by and large not as per the requirements of the question. So do not look for keywords, do not write with a preformed mindset. If one is not to look for keywords, what is one supposed to look for then? Look for leading words. These are some of the common leading words that any question paper of any law subject is likely to use. And each of these expressions has a different meaning. And that's the reason why they are different words to begin with. So enlist, enumerate, state, describe, discuss, or explain. Now, discuss and explain, they have been put in the same bracket, not because they are synonymous or anything. They are by no means synonymous. They are very different expressions, but they merit a long answer. And that is the reason, the only reason why they have been clubbed together. So discuss and explain is a long answer. State is a short answer. Illustrate is illustrate with the help of diagrams, tables, perhaps even case law. Uh, then analyze and examine. They are scientific expressions. So if the question is analyze, law is command of the sovereign, analyze. Okay, the idea is the paper setter wants you to break it down into component parts. So you'll have to deal with what is law. First of all, who gave this expression? John Austin. So when he gave this expression, what is his idea of law? Okay, which is uh, uh, something that you need to sort of deal with in the first instance. Then, what is his command theory? What is his idea of sovereignty, and how they are linked together finally, right? So you have to break it down into component parts. You have to approach the question in a very scientific, methodical fashion. That is what analyze and examine are asking you to do. Then we have compare, contrast. Compare is you need to focus, you need to place the two concepts, the ones that are supposed to be compared side by side. You have to focus on similarities more, and towards the end perhaps you can write a bit about how dissimilar the two concepts are, and then round it off in a very systematic fashion. Then contrast is you have to focus, you have to again place the two concepts side by side, and but now the emphasis should be on how dissimilar they are, and then towards the end mention a bit in a para or two about the similarities that they might have, right? So the thrust is on in compare on similarities more, in contrast it is on dissimilarities more. If the question is asking for distinguish between two concepts, that means the paper setter wants you to put emphasis on both the similarities as well as the dissimilarities in equal measure. So you have to balance the two, basically. So all these expressions, they are different, and they are asking for a different approach in the answer. So you have to do not look for keywords. Instead, look for leading words. Why are they known as leading words? Because they lead you towards a certain answer. And most often, most of the times, such leading words are built into the scheme of the questions. And the reason why they are built into the scheme is to give you a cue, give you a hint as to what is expected of you. So look for leading words, and more on these leading words. You can, those of whom want to read more on these leading words, you can, I'll give you a link of a certain resource towards the end of this presentation, which you can browse through. It is an open access SSRN paper, which I wrote long back. Now it is in the, I've placed it on SSRN so that more and more can benefit. So this is just to give you an idea that leading words are important. So there is a certain question which you have focused on. You have zeroed in on a certain question and you want to answer that question. Now, answering any question is like, you can equate it with that to that of flying a plane. Your takeoff and landing has to be perfect. That means your intro and conclusion, you have to spend a bit more of time and energy and effort in the introduction and the conclusion bit. Now, by that, having said that, I do not mean that you can fill the middle portion with trash. That is not the idea that I'm trying to convey here. What I'm trying to say rather is that it is the introduction and the conclusion that that is going to create a certain impression to begin with as to how much you know, or with what kind of an effort you have answered that question. Okay, so your application of mind would be visible more in the introduction and the conclusion bit. So spend a bit more time and energy. That would be my suggestion in the introduction and conclusion part. Okay, do not, and particularly for jurisprudence, typically totally theory, out and out theory based subject like jurisprudence, this is of utmost importance, which is the first bullet point that is appearing on your screen right now. Do not give the biography of the author. So if law is command of the sovereign, analyze. Yeah, that is the question. You are not supposed to, the question is not asking for the biography of John Austen कि वो कौन था, वो उसने क्या क्या काम किया, उसके famous works क्या हैं. Nobody is asking. The question is not asking you to write that. So do not feel as if it's your bounden duty to reproduce the biography. जीवनी लिखनी नहीं होती है. Fine. So do not give the biography of the author unless and until, of course, it has been asked. And usually it is not. Avoid winded beginnings and ends. Come to the point sooner than later, because if you keep building the preface, it becomes a drag, and it after 2 pages, if you haven't come to the point, then you have lost the whole essence of the question as such. You have managed to put that thing across to the examiner that you perhaps do not know, and you are just filling up space. So avoid long-winded beginnings and ends. So the last point here is be crisp and precise. Okay, so start sooner and end with a very precise, a very systematic summary. So this is it. And okay, yes, the third slide, the sixth in the order, actually. It's again, I would want you to spend 20 seconds on the what is there on the slide. Apply yourself. Yes, do not, and this is again linked with operating with a preformed mindset. If you have made up your mind that okay, ये question आया तो मैं ऐसे ही लिखूंगा, then you have the whole point of that question would go waste. When you are beginning to write an answer, you have to apply yourself. Do not operate as if as an automaton. Okay, because then the answer is unlikely to suit the requirements of the question. So apply yourselves. Think. Take a moment to think. there is sufficient time. If you are prepared well, there is sufficient time for you to answer in a systematic and complete fashion. Okay, so it is most of the times it uh, when the complaint of the students is कि बहुत lengthy question था या बहुत lengthy paper था, the complaint comes because not because and this is most of the times. I'm not saying stating it as a thumb rule that every time it happens this way, but most of the time the reason is because you haven't been able to manage the time. You have not understood the domain of the questions properly and have ended up writing more than required. Okay, so think, organize your thoughts. Those who can do it mentally, well and good, बहुत अच्छी बात है अगर आप सारी चीजें दिमाग में रख के ऑर्गेनाइज कर सकते हैं. Those who cannot, use rough space and write down there on the answer sheet that okay, this page is for rough space, and so that the evaluator does not end up evaluating even the rough column. Okay, so think, organize your thoughts, use rough space. Do not cook up stories. Do not cook up stories, because once you do not know means you do not know. uh, there cannot be chances of you taking a guess and then writing and the answer being correct are if you are really confident, I would say only then you do that. Otherwise, if you do not know, do not cook up stories, do not just fill up space. Okay, because that creates a very adverse impression on the evaluator about your caliber, right? Your whole credentials are at stake if you are cooking up stories, confabulating, and then writing nonsense in the paper. So do not fill up space just like that. And I have a few examples which might strike a chord better with the audience today, particularly the first years. So, yes, this is one. I hope the screen is clear. It's a very old scan, and yes, over the period of time, I do admit that it has become a bit hazy. But then, even when it was fresh, it was new in that sense. Even then, it did not make sense, right? Uh, all that I could make out was the ones that I have circled, and I believe the examinee has written, the candidate has written then. Only then I could make out. All the rest is garble, trash, right? So I failed. And usually students tend to resort to such tactics when they do not know. Okay, so I failed to read it. If it is not readable, even if you have filled up two extra sheets along with the main sheet, uh, if it is not understood at all, then do not expect marks on it. That is the idea that I'm wanting to convey. So I failed, and then of course the student failed the subject. Uh, I failed to understand, make any head or tail of this. Okay. Another example of filling up the answer sheet with um, whatever comes to your mind. So particularly the final year students, those who are attending this, those who are a part of the audience today, would relate to this. So it is Bhatna Vatna, and it is related with ADR, the final year subject. And again, you can read that it is all trash. So the question is, what is Batna? And A ने बाजार गया 100 रुपए लेकर Z नामक सामान खरीदने पर बाजार व सामान में सामान उपलब्ध नहीं था, परंतु उसकी जगह पर 90 या 110, and all is on and on and on for the first 20 sheets. All these tactics one should avoid. Okay, as I said, if you do not know, you do not know. Focus on what you know and put your energies there. That way, your chances of getting decent marks increase rather than resorting to such gimmicks in the while attempting the exam. Always be mindful of what is at stake. Okay, another. It says this is again the final year students are more likely to relate to it better. The communication techniques used by a mediator. So first communication technique, he has written head. The way a person's head is holding at the time of communication says a lot. And if it is up, then a person is confident. If the person nods his head up and down slowly, means it is paying attention. He is paying attention. Now, all this in an isolated fashion, this might make sense. But then, if we are linking it to the question that was put, if it is on communication techniques, and that too, the ones that are supposed to be used by a mediator during mediation, all this is nonsense. Okay, so as I said, even with this kind of filling up space, if you have even filled up two extra sheets, do not expect to get marks. Okay. Another, this is second year, so this is design. IPR is another subject that I teach, and design is something, again, it is all is not sensible. So this is geographical indication, and I've written there also a note what exactly is the meaning of this. The geographical indication is one of the basic parts of IPR, as it will tell about the basic things about a particular area. IPR could help over it so that, and it is as in the previous illustration or examples, going on and on. Well-known trademarks. Well-known trademarks. It comes in the section this, and it is blank. So clearly the student does not know. In this, there is namely showed that there will be trademarks when are etc etc etc. So all is basically useless for the purpose of the examiner. Yes, and many times, rather most of the times, the students have this thing in mind. Those who resort to such tactics, they have this misconception in their heads that the examiner would not know. As Dr. Shivani was also mentioning in at the start while building the preface for this webinar, uh, that the examiner would not know. So you just, or the task that you have is to just, fill the number of pages. The more the number of pages you fill, the more you are likely to score. That is a huge misconception. If you are moving on this presumption that examiner would not know, you are wrong, because they do. And they are very amused with what you write. Those of you of you who write in this fashion, the kind of examples that I have shared, you lose marks and you even fail. Okay, so it's your choice what you want to do. All right. Yes, this is something that I have been emphasizing from the first slide itself. So much is at stake. Give your subject the time, energy, and the respect that it merits. Yes, the examples must have made clear another aspect, must have emphasized or clarified another aspect, and that is handwriting. Handwriting, most of you are at a stage where you cannot do bring about a radical change in the way you write, but the least minimum that you need to ensure is that it is legible, it is making sense. Because if it is not making sense, then sympathetic marking usually is not done in law. कि कुछ तो लिखा है इसलिए कुछ तो marks मिल जाएं, even if it is not making sense, that does not happen. It does not work that way. Okay, so handwriting must be legible. At the same time, put some effort into the presentation of your answer, highlighting, underlining, side margins. Again, the old school method. All those tips that with which we grow up till at least the 12th standard. All those work here as well. Fine. Okay. Yes. Another example of difficult writing. I won't say that it's not legible, but then if the examiner is compelled to spend 1 hour in deciphering what you have written, then it takes a toll on the examiner. Examiners also are human beings. So do not test the patience of the examiner. Try your best in giving your best presentation to the answer, right? I can vaguely make out, this is again a jurisprudence paper, I can vaguely make out that yes, it is purity of norm that has been, so Hans Kelsen, purity of norm has been written about. But that is, with that cue, the examiner reads the whole answer and then tries to make out as to what is written. So as I said, put some effort in making your answer sheet presentable as well, because all the hard work that you put, if you are not able to present it uh, in such a fashion that it is appealing to the eye, it is readable in the first instance, then all is lost. So expression includes articulation, precision, coherence, and presentation of information. So your expression, yes, of course, you need to focus on articulation. That is the words that you have written, the words that you have chosen, and the expression that you have written. Fine, that is important to begin with. Uh, but at the same time, there is all what you have written should be coherent. It should make sense. So it should be presented in a very systematic fashion. Fine. When the answer is beginning and when it is ending, what is the question number which you have attempted, the correct question number, what is the order in which you are answering, all that should be. It should not become a task on part of the examiner to make out कि कौन सा नंबर का क्वेश्चन अटेम्प्ट किया है, लिखा क्या है, and so on and so forth. So use of headings, subheadings gives a structure to the presentation, and I strongly suggest and recommend students to use headings and subheadings instead of writing without any pause or any break or any space. Yes, so this is a good example. Notice the para again. This is a very old scan, and hence it has become a bit hazy. But even still, despite the fact that it is hazy, you can make out. I can still read that it is Roscoe Pound's jural postulates 1, 2, and 3 that this student has mentioned. Jural postulate 1: in a civilized society, every man must be able to assume that others will not commit intentional aggression upon him. I can make out. Okay. So look at the use of space, simplicity of presentation. I'm not asking you to use fancy highlight. That might not be necessary if your presentation is otherwise is good. So a simple way is before you on the slide. Okay. Another example from the final year again, Salami. So this is ADR paper, and notice the margins. So margins भी डाली हैं, और perhaps because the person knows that her or his handwriting is very small, the way the whole content has been organized, it gives a very readable look to it. Okay, so this again, this person has not used any fancy highlights, but still you feel like reading it. You feel like it makes sense from start till finish. Again, readable and good. So some highlights have been used, and it's Sir Henry Maine, again, jurisprudence, old scan. But you can still make out the development of law, static and progressive society. You can read. Yes. So 89.1 again ADR. So 89.1 CPC has been mentioned. Final year students would be able to relate to this slide better. The idea is not on the content. The idea is on the presentation. The whole focus why this example has been included is, and the previous ones, is presentation. So it is good. Law is command of the sovereign. Okay, Sir Henry Maine, evolution of law. Again, jurisprudence. Good use of space. Good use of space. So one line as you can see, has been left, and then the content begins. Then again, 1, 2, 3, 4, there is a line space, and then the next para begins. A bit too spaced out, but it's okay again, because I believe the candidate was aware that her or his handwriting is very small, and that's the reason why it has been spaced out. Okay, so the idea is put some effort, put some mind to making your answers presentable. Avoid this. This was I think 4 extra sheets and 1 main sheet. Why? Because there, as you can see, establishment of trade unions, so only 2 words per line. This also, or try not to operate on extremes. राइट इतना लिख दिया एक लाइन में कि उसे पढ़ा ही नहीं जा रहा, और इतना सिर्फ दो वर्ड्स ही लिखे पर लाइन, हर लाइन में, वो भी. ट्राई नॉट टू ऑपरेट ऑन extremes. Try to find that balance, that middle path while presentation. Okay, a few stray pointers. I'm coming to the end of my presentation. Do not attack the answer sheet. The idea is इतना आप उस पर पेन पर प्रेशर डालकर, पेज पर प्रेशर डालकर ना लिखें कि उसका इम्प्रेशन पीछे भी चला जाए और या वो शीट ही फट जाए, इतनी फ्लिमसी हो जाए कि वो फट जाए. So do not attack the answer sheet. You have to ensure that it survives, your answer sheet survives the whole checking process. Delete properly and neatly. Yes, another abuse of page or pages that students tend to indulge in is कि वो बिल्कुल ऐसा उसे डिलीट करेंगे कि उसे पढ़ा ही ना जाए. आप हाल तो कुछ भी ऐसा ना लिखें कि आप उसे चाह रहे हैं कि वो एग्जामिनर पढ़े ही ना. Fine. So you have to write as per the requirements of the question. If there is an occasion arises, if the chance, if there is an occasion for you to delete, okay, just a single line, horizontal line or a diagonal line across the sheet is sufficient with the words please omit. That is sufficient for you to indicate that you do not want the examiner to read that portion. So do not scribble unnecessarily on the answer sheet. These are some very basic fundamentals, but they spoil the aesthetics and they spoil the strength of that page also. Do not use red ink, not even for highlight. Never. Blue is the standard that is followed. Okay. So red, pink, and analogous colors are not to be used. They are the prerogative of the paper checker, the evaluator, not the examiner. And finally, yes, words matter. The do not go with this presumption that what you write is not read. Everything is read by and large, okay? And on that basis, your mark. So words matter. Word limit matters. This is not in English literature. You are into law. Yes, we cannot give you word limits per answer. कि 500 words में लिखना है, 700 words में लिखना है. But most of the times, the students do have an idea. If they have understood the domain of the question properly, you do have an idea on how much is expected out of you. So again, the general guideline that I can give you here is do not operate on extremes. आपसे एक simple सा state क्वेश्चन पूछा है या आपसे सिंपल एनालिसिस एग्जामिन क्वेश्चन पूछा है और आपने उस पर 20 पेज भर दिए, दैट इज वन एक्सट्रीम. और या आपसे एक्सप्लेन या डिस्कस लेंदी आंसर क्वेश्चन है और आपने उस हर चीज बुलेट पॉइंट्स में लिख दी, दैट इज अनदर एक्सट्रीम. In both the cases, you end up losing marks. So do not operate on extremes. Rely on your sense, good sense, on what is the limit within which you should write. Okay. Your hand, head, and heart should be in sync. That is the last piece of suggestion. आपका दिमाग कुछ सोच रहा है, आपके दिल में कुछ है और आपका हाथ कुछ और ही लिख रहा है. उस तरह से लिखेंगे, so obviously it is going to reflect in the answer and in the ultimate score that you get. That is all from my side. Those who want to read a bit more about it, then you can access this social science research network paper and you would find more on whatever I've shared just now with you. Thank you so much and good luck with all your efforts.
There are so many students so eager to learn, and now I humbly request you to address our participants. So we all know that ma'am is known for her excellent teaching skills and articulations. I'm so sure that all of us are going to be benefited with her vast experience and knowledge today. Ma'am will be talking about the subject law of crimes, and definitely we are going to learn a lot about how to write answers for this particular subject from ma'am. So over to you, ma'am. Thank you so much for joining us.
Thank you, Shivani, for giving me that opportunity. But at the outset, let me admit I have missed the opportunity of listening to Professor Sunanda, wherein I believe she must have shared the PPT, and I still am vividly remembering 4 years back I took a session on how to write exams, and it was a very well formulated and displayed PowerPoint presentation as such. So just assuming that she has further developed on that. So basically the gist is there with the students, and what I would very inform them is that as far as criminal law is concerned, we need to understand that there is no one clear and short answer. It's all about how you are convincing the reader that your justification or explanation is the correct appreciation of facts and the application of law in the given scenario. So when we are talking about criminal law, a couple of points that we need to remember is that, like any other question paper, we should have a clarity that we read the question very clearly. We understand the demand of the question. From our side, we have ensured that the questions are very focused so that the student cannot think on different lines and then find it confusing as to what specific law is being asked for and about. So first advice is that please read the question clearly and figure out what is the demand of the question. Because every problem, any instance that has been shared or formulated about would have several aspects to deal with. It's only the question raised that needs to be addressed. So when we are talking about any problem-based question, be very clear that while you are writing your answer, first identify that this given problem is from a specific topic, from a specific question, a specific law. So having identified from which particular topic and law a given question has been framed, lay down the essential components of that question. In the sense that if, say, for example, there is a question on kidnapping for law guardianship. So please inform what are the essential components of kidnapping as an offense. Mind you, you are not expected to remember as a rote learner that this is the language with ifs and buts and all that. But yes, those ifs and buts would certainly be important and relevant when we talk about identifying the essentials of a given offense. Or for that matter, when we talk about the principles of liability. So when you are talking about strict liability or mens rea, we all understand the words are very important. Say, for example, Narayan Singh's case, the moment there is that word or otherwise included, it has brought about the whole reversal of the jurisprudence and the thought process that even if there is an intention or knowledge or it is non-existent, it would be similarly treated as an offense provided the prohibited conduct has been indulged in. So please be careful and cautious about the words, but at the same time, remember that we do not expect the students to remember and write down each and every section in detail. Remember that and write down. So essential components is the second aspect. Finding and identifying a question that it belongs to a given law. Then what are the essential components? Once you have written down what are the essential components, then please explain, interpret. And when I say explain and interpret, the meaning is that if we have discussed cases dealing with the understanding or how the given phrase or the sentence of the law is to be read. Say, for example, if I pick up 299, it says whoever causes death. So when it says whoever causes death, does it say whoever causes death of the person? It doesn't. To that effect, you have got section 299 and the illustration. Even the illustration doesn't talk about the identified deceased victim. Similarly, you have got section 300 also. So please take care that when we are saying whoever causes death, whoever means a man or a woman. So how do we say whoever is a man or a woman? Then we have got the section 8 which says he or she. And in that context, what we also need to remember is that illustrations and explanations are also very relevant. So please do not commit a mistake wherein you think that only the section is relevant, because explanations are giving meaning, the content, the scope, and the amplitude within which a given law is applicable. And then illustrations are examples for sure. And depending upon what is the problem based on what are the facts, you may pick up a given illustration and you may not talk about all the illustrations. But please mind you, you cannot avoid talking about the explanations again in gist. So having talked about the essential components of a given offense, maybe in bullet form, you need to explain those uh, essential components with the help of cases. So having done that, when we say analysis, that's the analysis of law. Then we come to the application of law, meaning thereby, then you are picking up the factual scenario. Having picked up the factual scenario, then you are applying the law that has already been discussed by you in the preceding segment. So when we say analysis of law with the help of cases, and then you are applying the law to the factual scenario, then you would say that in the given fact scenario, this particular law, these essential components are there, and that's very important. And when I say that's very important, it means that whether you have a clarity about the application of law or not, in the sense that when we say application of law, you would be explaining, you would be reasoning, you would be logically justifying that why are you saying that this particular section is applicable or not in the given fact scenario. Please note that there is no mathematical evaluation, meaning thereby, even if you have wrongly applied, there will be certain situations, certain factual scenarios which would be crystal clear, so that there is no possibility of arguing the other way. But there would also be, and there may also be illustrations, and that's generally the routine, that which are open both ways, that you can argue for or against, meaning thereby that this is an offense falling under kidnapping, this is not an offense falling under kidnapping. Or for that matter, misappropriation of property or no misappropriation of property, or for that matter, even with reference to group liability and private defense. So when we are talking about open-ended questions, it means that we leave that scope as the drafters of the questions, that the student can pick up, and it's all about thinking about the conceptual clarity and the possibility of arguing for or against. So when we say application of law means that there is the conceptual clarity about what a given phrase stands for, what is the meaning of the essential component, and how do we apply it in the given fact scenario. And when we are applying, we are reasoning that why do I think the way I think, and why, and even if why I think the way I think, I am giving additional information, and that's where, please notice, the cases that we may have discussed already in the preceding section, while analyzing the case, while analyzing the, you have to repeat, you should again mention that as already discussed in the preceding section with reference to this particular component. Say for example, if we are talking about Virsa Singh or Arpunaya with reference to 303rd, that even if there is a single row, Virsa Singh has already informed in the preceding section, the court has laid down a principle of deeming fiction that assumed to be the desired injury, irrespective of the fact that the accused is claiming aloud that he has inflicted only a single injury. So that would just close for you and the reader that the person has a conceptual clarity that in case there is a single injury, how do we determine as to whether this is the desired injury, which is an essential requirement for the application of 330. The rest of the things are objective with reference to section 330, that there is an injury found on the person of the deceased, that's the cause of the death of the deceased, and this injury was sufficient in the ordinary course of nature to cause death. That being so, the only requirement is with reference to the subjectivity of the accused, whether he wanted to cause that very injury or it happens to be an accidental or mistaken injury. The moment you have been able to rule out that accident or mistaken injury, and we have quoted Virsa Singh, your job is done. You have clinched the marks and the heart and mind of the reader that here is a student, here is a person, a researcher who knows what is the concept and there is the clarity. But at the same time, a person, a student who knows the concept, but there has been a misunderstanding with reference to the application of law in the given scenario. It's not that the student would get a 0. It's only with reference to the application of law there would be the loss of marks. Otherwise, since you have jotted down the essential components of the law, you have also talked about the analysis of law, you have mentioned the cases which are relevant cases. Please ensure that you do not write all the cases which are there in the printed material, irrespective of the fact whether they are required or desired, because there may be just one aspect in the problem that has been asked. And with reference to that, you need to respond. So it's not that anything and everything pertaining to group liability, you will be talking about everything. Or for that matter, when we are talking about private defense, you will be talking about all the cases. You may not. So it is for you to decide what are the relevant cases that you need to jot down and why they are relevant. So that when you are applying the law, application of law, you would be utilizing those cases. And please bear in mind there may be illustrations that you do not have a case. Doesn't mind. There would be situations that you do not remember the name of the case. Don't worry. There's no worry, and do not bother yourself that you do not remember the citation. If you remember the citation, nothing like that. If you happen to remember only the case, even that's really good. And if you do not remember even the year of the case, doesn't matter. Remember the name. And lo and behold, in case you happen to forget the name of the case, doesn't matter. Then instead of writing any other false name or a fake name, just to create an impression that you have read something and there's a case like that, please understand that the evaluators are people who have been into the system, who have been teaching, reading, writing for at least a decade or so. So they are all aware of what are the cases which are dealing with a relevant fact or factual scenario, or for that matter the concept. So please don't try to be fooled by putting fake names. Be honest. We are not going to anyway tax you for that you do not remember the name of the case. Certainly, subjectively there would be a lesser advantage, but you would not be negatively marked. And it's all about relative evaluation, so that if the students are there who have written the case name clearly with the year and the page number, they would get an edge. But that does not mean that you would be taxed and your marks would be deducted because you do not remember the year and the full citation. So please don't be panicky on that ground. And coming back to the steps of the question, having analyzed and applied the law to the given problem, then there has to be the decision of the case. And whatever decision you give, please again, in a line or two, just jot down your reason, your justification, rationale, reason, whichever name you call it, that why you are deciding it the way you decide. So, in brief, if I might go back, informing the steps, it's first identifying the issue. Secondly, identifying the law that is applicable. Thirdly, what are the essential components of that law? Fourthly, what is the analysis of the law? Then you have got the application of the law. And then when we are saying application of the law means that the issues that you had raised in the first go are being addressed with the help of the law and the analysis of the law, and the same is being now at that stage applied. And then there would be towards the end the decision. And the last of all, if there is a situation and a scenario, I'm sure that all my colleagues pertaining to criminal law would have dealt with those cases which are doubtful as far as their decisions have been delivered. So if we are talking about, say, Palani Gaon, then we have got another case which Thavamani, which is the other way around. We have got Cherubin Gregory's case wherein we can have possibly a reservation that this should not have been a case under 304A, instead it should have been a case under 299. Similarly, we have got Kapoor Singh's case wherein we can think differently, saying that 199 and 300. Or for that matter, Vardarajan's case wherein we say they have very clearly said that he has not taken away, but they have not taken into consideration the other word which is very important, which is enticement. They said that the girl called up Vardarajan. But I can as well argue that why should we not look into the fact that what made the girl to call Vardarajan? What was the relationship in the past between Vardarajan and Savitri? So those illustrations and situations wherein we have got a reservation with reference to the judgment delivered by the court, that's what I have been informing my students in my class. Please notice, we have got the liberty and freedom to criticize the judgment of the court, but then there is a way of writing that. So wherever you have got a difference of opinion and you want to state that your disagreement with reference to a judgment may be of the Supreme Court. That's how the law develops. That's how there is the possibility of review and revision. So there's no foreclosing the option that once there is a case decided by the Supreme Court, it cannot be undone, it cannot be changed. There is that possibility. That's how we know that from lower court to the high court to the highest court, the decisions do change. So similarly, even within the Supreme Court, one bench deciding a case happens to change the ruling in subsequent cases in almost similar facts. When you graduate over to the second term, you would read Gyan Singh and Deepak's case, which are dealing with the inherent power of the High Court. In fact, the inherent power of High Court under section 482 of the CRPC. You would find Justice Markandeya Karju is explicitly on record saying that these three judgments have been wrongly decided by me. So Justice Karju is himself confessing on record in the subsequent Gyan Singh's case that the previous three judgments were not correctly decided. So please note that it is for us to analyze the application of law, whether it has been rightly done or not. So don't be afraid, but only one caution, that wherever you have your reservations, which is the politically correct word, if you have got your disagreement with a given judgment, write down towards the end that, however, I beg to differ with the judgment delivered by the Supreme Court or the High Court on the following grounds. So it's not only that I do not agree, you have to state the reasons. Otherwise, merely saying that I do not agree, this is not a legal argument. You have to develop legal arguments. So when you are saying that I do not agree with the judgment of this court, so please write, I beg to differ from the judgment delivered by this honorable court in this case on the following grounds. So please ensure you substantiate your reasons, your answer, that why do you have any reservation or disagreement with the judgment delivered by a court. Otherwise, it amounts to intent, amounts to contempt of court. So once you have given the reasons, then you can say, this should have been decided in this manner. That is the critical analysis. So you are free to critically analyze, but please bear in mind, mere criticism is not what is legally permissible. It is the critical analysis, so that criticizing a judgment, you are coming up with your own logic, rationale, and argument as to why this is how the facts should have been analyzed and the law should have been applied. So that is it from my side for the time being. This is what essentially is required with reference to the papers of law of crimes. But please notice towards the end again one request. caution, and an advice. Be prepared that there can be two parts of a question A and B, and then the two can belong to two different segments, two different topics. So don't think that there is a question on kidnapping, it would be only on kidnapping. There can be a property offense as well. So please be prepared from that standpoint, and wishing you all the best so that you write your exam. This is the first term that you are going to write your exam from not within the core paper. So don't be afraid. We are all learning. All the best and good luck.
Thank you so much, ma'am, for a wonderful, wonderful session. It was indeed quite enlightening. So, answer, I think, is not a mechanical exercise. We all know it is not about throwing every word you remember on a piece of paper. As ma'am was telling, it requires a lot of comprehension and strategization. And as ma'am was telling, it's completely right that you need to understand the facts and application of law in the given context. That makes an answer impressive, and probably you'll be able to fetch good scores then. So now I would like to call Professor Dr. Ratnavali ma'am. She definitely makes a subject so easy to understand for her students in the classroom, and I'm sure today she's going to make answer writing also a bit easy for all of us. Let's take this opportunity and learn the skill from ma'am today. So over to you, ma'am. Thank you so much for joining us, and we welcome you here.
And my dear students, I believe that students in for this particular session are first year students, and since I was not able to join from the very beginning because of login issues, I was trying to take a brief summary about what Sunanda has covered, and I could the points of how to write a answer, what are the do's and don'ts of while attempting the examination has been mostly covered. But I would like to share with the students that after all, whatever you are writing is going to be assessed and evaluated by the teachers, and teachers are all human beings, so it's very important to understand the disparity that may arise, and disparity, or as well as I would say in terms of the impact a particular answer can make on the evaluator, because many a times what happens is that we evaluate a lot of papers as we have large number of students, and if we read the same type of answer again and again in every answer sheet, where one is particularly say referring a particular book or otherwise to write an answer, that does not give an interesting way of reading the answer and evaluating. So I would give a small advisory in this from this perspective, that if you're writing, particularly when you are writing a theoretical answer question where it is not based on hypothetical cases, then it's always good to have a very original introductory paragraph as well as a concluding paragraph. Then it when you read the answer, rather than just writing the section and then going ahead with explaining through the cases and all, it's very good to attract the attention of the evaluator or the examiner by writing a good paragraph. Maybe it shouldn't be a big paragraph, just 3-4 lines about the issue that is being focused in that particular question. So then you are able to attract the attention, draw the attention of the examiner, and we feel that okay, this is something different, and therefore you should be able to attract the attention and utilize that particular focus of the examiner in examining your script well, because it shouldn't be a routine kind of answer, and that is the first thing. Similarly, when you are concluding, there should be a very clarity on your perspective about that particular issue asked in the question, and if there are if you feel that the way the law has been interpreted because statute, it is fixed, but how we interpret may differ. That's why we see so many differing opinions of judges of, different courts on the same provision of law. So I think it's also important to give your perspective about what you think is the right way of interpretation, your own opinion, and then substantiate. So that way, when you conclude, it gives that an impression to the examiner that you have read the law properly, you have comprehended, and you are able to analyze different interpretation of the same provision, and you are able to come up with your own, with a justification or a rationale for it. That is the first point. Second point is that when I see answer scripts where both the right and left margin, students are leaving about 1.5 inch or 2 inches, and they're writing in the middle portion where you can see maybe a maximum of 4 words per line. That kind of puts at least as an examiner, that puts me off, because one can infer from such an act that the student is just trying to fill number of pages rather than the content part of it. And since you are students of law, you have already done graduation, and as a educated person, I would at least expect the students to utilize the paper properly, because more pages means cutting more trees. I think that kind of awareness I would like to see in the students of law. So therefore, my advisory would be that in order to give a such negative impression about the examinee, kindly leave maybe 1.5 margin on the 1 to 1.5 inch margin on the left side, and write the rest of the paper you can use for writing the answer, so that there is space enough for these teachers to give the marks on the margin, on the left margin of the page. Third thing I would like to advise to all the students is that while writing the answer, kindly, if you are finishing at, say, little more than a midway of a page, then write, maybe you can draw a line or leave 1 or 2 lines just to draw the attention of the examiner that you are starting now with a new answer. So I think that needs to be prominently, highlighted, so that it shouldn't be that, while flipping the pages, teachers are unaware about the starting of a new answer. This is only for as a matter of caution, but otherwise I know for sure that teachers do read line by line, page by page. But just for clarity's sake, that, it's better that you have a different indication of the starting of a answer, finishing one and starting the next. Fourth thing I would like to tell the students, that if you are opting to write in English medium, and if you are not comfortable in English as such, then it is advisable to write in Hindi, which, if you find that Hindi is a much more comfortable language of expression for you, because what is important is to communicate your understanding of law. Just because it's not that if you're writing in English, the impression of the teacher will be that you know the law better. It's not like that. But if you are comfortable in conveying, fourth point is that when you write an answer, kindly indicate the answer number corresponding to the question number, because sometimes students write answer number 1. You may be attempting the third question as the first question, so you have to write question number 3 rather than answer number 1. So you please write answer number 3 corresponding to the question number, not the serial number of, not that this is the first question I'm answering, so it shouldn't be written as answer number 1, because it may create confusion in the mind of the examiner. So kindly, whenever you answer a question, mention the question number and write when you answer that particular answer. Fifth point I would like to focus is that, I was talking about the medium. So first, whatever medium you're comfortable with, whether it's English or Hindi, kindly use it. Writing in English doesn't mean that you are a better, understanding of the law. I think that was what I was talking about before leaving. Now coming to the law of contract, how when we talk about subject specific, the question paper, as you all know, you have to attempt out of 8 questions, 5 questions have to be answered. Now, kindly do not just pick 5 topics and prepare, because there can be combinations also, as I think Professor Anju has already specified that there is possibility of mixing 2 topics and give an question. Similarly, when you have question like writing a short note where maybe 3 topics are given, and so those 3 will be belonging to different topics listed as per the contents of law of contracts. So therefore, I think it's very safe that it's safer for you all to prepare the syllabi that is being covered as such, rather than picking and choosing, because that may lead to not being able to get complete 5 questions out of the 8 questions. Now, if I refer to the contents of the law of contract, we all know that it's the main law starts from topic number 2, where we are focusing upon offer, acceptance, revocation. So this particular topic, whenever you are answering any question, what we need to emphasize, what we need to prepare is the essentials of these sections. They are being covered in each of the topics, number 1. So you need not, by heart the whole section word by word. So when you read the question, when you read the section, you just identify what are the essential points, number 1. Number 2, whenever you are looking at those essentials, we need to then go one by one. How do you interpret all these essential ingredients? Fine. And for going to the interpretation of the words that are being used and you have listed down in the essential ingredients, one has to take into consideration the interpretation given through different case law that we have already covered. Say, for example, when we are talking about offer, we say that when a person signifies, so what is the meaning of the word signify? You need to explain. How do you communicate then? So different ways of communicating you have to mention, as well as the mode of communication. So therefore you need to cite different cases, as well as while explaining each of the essentials of the provision of law that you are citing. Now, as Professor Anju has already talked about, when you answer a question, first you need to identify what is the issue involved, because topic number 2, when we are talking about offer, acceptance, and we also talk about invitation to offer. So therefore, we first need to identify what exactly is the focus of the question, and accordingly you have to cite the relevant provision of law, list down the ingredients, explain those ingredients with the help of law. So, and in case if it is a hypothetical question, it is always good to start with what are the facts involved, number 1. Number 2, write what are the legal points that are involved in that particular, the hypothetical facts that are given. The legal issues involved can be the second part of it. And then once you have identified what are the legal issues involved, then you can come to the legal provisions which are relevant for the purpose of looking at those legal issues. So that can be the third part. And when you are trying to explain the third part, you have to help of the case law in order to elaborate upon those provisions of these sections. So then obviously fourth point, when we are talking about solving the hypothetical questions, you have to apply whatever law you have understood in the facts of the case. Now, many a times, if you look at the hypothetical questions, you may feel that the facts given are not complete. So, whenever some facts are silent, then you have to attempt the answer, apply the law in two provisions. Say, so you have to take both the alternatives of the situation. Say, for example, if you are talking, say, in a question it says that the offer has been communicated, but it doesn't say that how it has been communicated, right? The other is the instantaneous means of communication. So therefore, in case the mode of communication is not given in the question paper, in that case you have to say, in the case of this, in this situation it would be like this, whereas in the other situation, if you adopt a different mode of communication, it will be the decision will be going in a different direction. So if facts are silent on certain position of law, then in that case, while applying or while deciding that particular case, you need to give both sides. If the facts is like this is the decision that you will, this is the line of argument and decision you will take. In case if the fact is, if the fact is otherwise, then it will be, because sometimes facts are made silent in a question so as to see how a student will decide. So therefore, you need to read the question and then cull out the relevant facts, right? So that you are able to see what facts are silent, and therefore you have to adopt both the line of argument and then come to the decision part. And therefore, once you do apply the law, and last would be your decision, and therefore you can come to a clarity on what is the decision, plus along with that, what is the rationale or the reason or the justification that you are coming to that decision. And therefore, such judgment, when you give the decision at the end, you have to always support it with the relevant case law that you have already mentioned. So I think if you don't want to repeat it again, it's good that if you are able to along with where you have talked about based on this, or this, which is you can say the decision is supported by so and so case, which is dealt with under so and so paragraph of your answer. If that is fine, well and good. If not, don't waste time in writing the answer, and you can say the case already aforementioned or already discussing this answer. This is the basis on which I am, my decision or the decision I am giving is being supported by. So this is one, the way of hypothetical questions, and those facts will be mainly based on the cases that you have studied. Since it is a semester 1 paper, you may not find, very many new facts into it. And I feel that you should not be having any problem in coming or arriving at which case law is relevant and which is the law point that is being asked in a question. And I also would like to reiterate the point which I think Professor Sunanda and Professor Sunanda has specifically focused, that is, don't write the answer just because you first identify that from this topic this particular question has been asked, and you start writing whatever relating to that particular topic. No, that shouldn't be the way of answering a question. So read carefully the question, whether it is asking for explanation, whether it is asking for elucidation, or whether it is asking for critically analyzing the issue. So reading carefully that question and accordingly answering it will secure better marks as compared to your peers who do not do so. Because we always tend to give more marks as an examiner. At least I can share my own experience that you tend to give more marks to those students who give analysis rather than just reproduce what he or she has memorized. And many times you can see in the examination hall also, and you will see this time when you are going to sit for the first exam, that the moment they receive the answer sheet, rather than just writing the details on the front page, they will start writing whatever case name of the cases that they remember at that point in time, because they feel that they'll forget once they start writing the answer. So the whole process of writing the examination should not be devoted to just rote learning or memorizing it only to be reproduced on the day of examination and then forget, because the intention of the entire evaluation or assessment process is not to look at how much you are able to memorize, but how much you are able to absorb whatever has been learned, and then you are able to analyze and reproduce what your understanding of law is. So therefore, you should shift your focus from memorizing to understanding the law, analyzing it, and then reproducing later on as per the question. If you do this or follow this method, and I'm sure that you'll be able to secure very good marks, because if you reproduce just the relevant law and cases, you may be able to get 60%, but you will not be able to cross 70%. So if you want to score high, you have to show your understanding of law. So therefore, and it's not that filling up the many number of pages, multiple pages or answers sheets and additional supplementary sheets is not required, as long as you are writing in mind the marks allocated for that particular answer. Because sometimes you may get a questions where you have 4 sub units where you are supposed to attempt at least for 5 marks those 4 sub questions within one question. So therefore you have to check how much you should write, because for 5 marks you should be writing each answer if you have 4 sub questions. Therefore you should time your I would say briefly write the answer, as well as keep a tab on you are sending the question. See, you have 3 hours to write the 5 answers. So in all, if you look at the first answer that you will be attempting, will always be the best answer, a question whose answer you know very well. So therefore, you can invest say maybe about 45 minutes or so per answer. The second question may again be about 35 to 40 minutes. The rest of the answer where you have to write 3 more answers. So at least half an hour you have to keep a tab. And let me tell you, we have seen, we find answers where it's very well written, comprehensive answers is written, but they are able to write say 3.5 answers. So in spite of getting good marks in first 2 questions, the person may just be able to pass, or maximum say if you write 3 questions, you may be able to get somewhere around in 50s. So they should kindly make brief notes, so that in case if you are writing in a concise way, all the points are covered, then you will be able to get say if you get out of 20 15 marks each, then straight away you'll be able to get 75. But then if you are able to write very good answer, you are getting say 16 or 17 marks per answer, but you are able to write say only 2.5 to 3 answers. So that's not going to, if you get 16 also, 3 is 48 only. So therefore I think time management is a very, very important part of the strategy of attempting your question paper properly with an aim to secure good marks. Because after all, assessment, the marks that you get will also reflect, though I would not say that it's a 100% reflection of whatever you know, but that is the only, I would say, realistic or concrete way as of now to find out how much you have learned. And therefore, that will have an impact upon your placement, upon your, career path. So I think keeping all these in mind is very, very important. And so just look at what the nature of the question, read carefully, and then whether it is hypothetical question, I've already said how you should be writing, starting from the facts involved, and then issues, then the legal provisions, relevant legal provisions, application of those, and then the conclusion. Similarly, in the case of theory-based questions, you have to please try to write a very good introduction, not very long, 3 to 4 lines, and then have a good conclusion, giving all perspective of that particular law. So this would be, I would say, very broad, advisory on how to, attempt the coming examination. And I wish each one of you the very best. And I think doing a very, very focused study now is very important. And in case if you still find difficulty or confused, got into certain topics, you can, my students who are here, whom I have taught, they can always get back to me through WhatsApp. They already have the number, and we will be always be there to guide you, to give clarity in case if you still have some doubt in any topic. And I wish you all the very best. Thank you so much.
Thank you so much, ma'am, for the session. And we are actually looking forward to hear more from you. Thank you for having us, ma'am. Thank you so much. So now I would like to call Dr. Siddharth Mishra. Sir is an excellent teacher with very vast experience. He has been teaching law of torts since long. And torts, as we all know, is a judgment law and a case-based subject primarily. And this makes answer writing even more tricky when it comes to law of torts. It's an honor and privilege to have Siddharth sir with us. And I know sir is going to help you all understand what it takes to write answer for this particular subject. So thank you so much, sir, for joining us today. And over to you, sir. We are looking forward to hear from you.
Thank you very much, Dr. Shivani. And I'd like to say a very honorable Professor Judge, ma'am, and all my distinguished colleagues here, as well as all the students. Though it's so, perhaps I would also like to say something on this, and that might perhaps give some help to the students. See, I think that I would start this with sharing with them my own experience as an examiner. As to what do I actually look up for in a sheet which is going to be checked by me in an examination, as an examiner. See, actually, I should be very legible. Most every examiner, for that matter, that the sheet that they are checking is written well in the sense that it is legible. It is legible. That you can actually read as to what exactly is written. Because I have noticed that some students write well and very legibly, and that gives you happiness, and that actually makes you comfortable in reading the sheet. And if something is not written legibly, then as an examiner I get irritated, because I have really put pressure to actually understand as to what exactly is written, and I have to struggle to understand what is student has written. So that is perhaps one of the first impressions that an examiner would get from a student. So every student has to focus on writing legibly, and they must practice writing frequently so as to improve their writing, for that matter, from the point of view of legibility. Second aspect, which I have experienced as an examiner in whichever subject I've been checking, not specifically for thought, that the students at times that I come across a sheet and a student has written really very well, and the student has written all the questions well, and as I have ended up marking him on the fourth question, I see that there is no fifth question attempted. So I feel pained that I was willing to give this student who written so well good marks, but that he has not attempted the last question. And I'm appalled but I'm helpless that even if I wish to give marks, I can't give because there is no question attempted. So, like Professor Ratnabali also mentioned the same thing, that there has to be a focus on time management, and I think that will come with practice. The students still have time, although I always suggest the students that the writing doesn't happen suddenly, it doesn't happen overnight, and it's a process, and it requires practice. So no student should be complacent about their writing capacities, because for the first years it becomes all the more important because they are newly introduced to the subject. It's a different subject matter for them. So they may take some of them may take some time in even comprehending the subject. So it's really advisable that at the end of every topic that they practice writing. This is for the future semester that I've been advising, but even now they have the time, so they can just take up previous year's questions and attempt them as well as possible, keeping in mind both these two factors, especially the legibility of writing as well as time management, so that they got enough time to be able to attempt all the questions, so that they will get all the full marks on all the questions for that matter. So these are two very perhaps the simple advices that I would give, but they become very important at times. When we come to writing the question paper, writing the answers to the questions, see, it's very obvious that I have seen that students commit very slight mistakes while writing, and it happens because perhaps they do not focus upon their language skills, and and suddenly when they're required to write something which is on a professional discipline, so they come across difficulty. So it again would require practice. So so writing is language understanding with the understanding of law is really very important. So they have to practice upon the enhancing their understanding of the language as well. So besides that, I would say that because when we talk about the question paper as it comes, it has various questions, and as the trend we follow in law faculty, the emphasis is on keeping some majority of the questions on application. They should be based upon application. And as we've been following the case-based study, I think every student knows that, and they even become accustomed to pursuing a case-based study. So the emphasis in the examination, the question paper, as is the instruction to the examiners also, that they should keep more application-based questions and lesser theoretical questions. So it obviously will depend upon what is the language of the question. So every student has to very patiently first read the language of the question, that how it is written, what exactly is it asking. So if it's a problem-based question, if it's an application-based question, which obviously will be a hypothetical question and will be based upon any case which they have been taught in the semester. So they have to adopt slight different approaches in terms of answering both the type of questions, because application based or theory based. And that the questions may be longer. There will be one long question carrying 20 marks, then there will be one question carrying 10 marks, and then a short question carrying 10 marks. So accordingly, they will be required to write in terms of the number of pages, to how many pages do they need to write. So for example, on a longer question, how much are they supposed to write, and on a shorter question, how many pages are they supposed to write now. That should be kept in mind. It's very obvious that it may not be very lengthy, obviously. It has to be very pertinent from point to point and logical, to be very concisely and precisely written, because in law we do not really look up for the length of the answer, we look up for the content of the answer. So that is something that should be taken into account. And it comes the subject that is the law of tort. Law of tort, as you know, it has two parts, part A, part B. Part A has 8 topics and part has one topic, that is the consumer protection. There will be question on the consumer protection. And in the examination, there will be 8 questions. 8 questions, 6 questions from part A, 2 questions from part B. Students will be required to attempt 5 questions out of 8 questions, in which 1 question shall be compulsory from part B. So in all, there will be 5 questions that they will be required to attempt, including 1 question compulsorily from part B. So, that because majority of the syllabus is on the law of tort, that is from the concepts of tort, and that there is no legislation upon that. And that, that's a case-based study. The tort, as we teach in our syllabus, the first part A having 8 topics, the case-based study, and in which, we study cases mainly, coming from the UK, the common law cases coming from various higher courts in UK, such as the House of Lords and the Court of Appeal, and even from the Privy Council as well. And then we study cases in Indian context also, because we are studying law of tort in Indian context. So we have been, wherever and wherever possible, we have incorporated the Indian court judgments, there is a Supreme Court of India and there is High Court judgments in the context, so far as they are found to be suitable and relevant. So, while writing an answer to a question, it obviously would depend upon what is the language of the question. If it's a problem-based question, if it's an application-based question, then it's very obvious that we need to solve the problem. But it doesn't mean that you will not mention the law. It doesn't mean that you would not mention the law. You will just, in few words, solve the question and write in a paragraph the answer. No, it is fine that you write in a paragraph the answer, but then you have to elaborate it, with the help of the legal position as to how the law is, how it evolved perhaps, and how, it happens to be at the time being. You have to, because the way we discussed the subject, the way the syllabus has been drafted, we have been discussing all the topics in the historical context, that what was the issue which was being felt by the courts, which required legal principles, how on those issues the cognizances were taken by the courts, either that they received a case or maybe, in some other way, but that they held principles. And those principles gradually evolved into a separate category of torts. And as we have seen that one of the the main topic of the tort, which is negligence, which is almost 3 topics in the syllabus. We have in the classes seen that how negligence gradually evolved as a tort and came to acquire its own separate ingredients. So apart from just being a mental state of mind, negligence generally is the state of mind, it acquired the characteristic of being a separate category of tort in itself, having its own ingredients. And that is the case with most of the tort that we have seen, that each of the tort has its own ingredients. So, it's really good that if the students have the knowledge, they have studied the concept well, then they will be able to write, in a sequence, that how things have evolved, how the law has come about to be as it exists today. So, giving the classic judgments, as have been told by my other colleagues also, you have to remember their names, you have to remember the facts, and as a judgment, as we study, it has 3 important parts: the facts, the principles, applied upon those facts, and then the judgment. So from the point of view of a law student, what is more important is the middle part, that is the principle, the logic that the court has evolved to reach a particular judgment. So we always emphasize upon that part, when the student should really know. And that is, which may be consisting of ratio as well as orbiter, that you have to have that uncanny knack in you to be able to, fit, so, so writing an answer is an art to my mind. It is a creativity, which some people may have inherently in them, but some people may acquire that with a slight practice. So, because I have been asked that the earlier speakers, the earlier professors have already provided all the details to the students. So I would not take much time, but would say just end this by saying that you must obviously provide the Indian position in the questions. It's really advisable to mention the Indian position, the Indian contracts, that whether there are some judgments which have been given on the relevant point, relevant issue from Indian courts as well. So this is starting from the British courts decisions and evolving tracing the evolution of the very law, how it has come about to be, and then what happens to be the current position. You may mention all this, but you have to do all this in a very creative manner so that you keep into mind that you retain the content, you retain the ratio, and that you do not cross the worm limits as well. Because some students I have noticed that they will not be coming to the point. They will be hovering around. They will be hovering around. So this is what the students have to understand, that law is not what they feel is law. The law is what is imbibed in the judgments or imbibed in the statute. So this is what they have to pinpoint on. You can obviously use your own language as well, but that that has to be used also in a very creative manner, subject to the reasonable restrictions. So I think that with this I would end, and I would really love if we could open this floor for discussion, or maybe some students will have some queries to me on the law of God, okay, or in the questions on the law of God.
Thank you so much, sir. So now the session is over from our side.